Everyone, and thank you for joining for today's webinar on judicial advocacy. My name is Olivia Backus, and I'm a staff attorney with Aimed Alliance. We're excited to have you join us for this conversation on how healthcare access advocates can engage with the judicial system and how it can serve as a powerful tool to complement advocacy efforts in the legislative and executive branches. Please note that today's webinar is being recorded and will be posted online following the event. And if you have any questions during the presentation, there will be a time at the end for Q&A. You're welcome to submit your questions using the Q&A chat or the raise hand feature if you'd like to be unmuted. Today's conversation will be led by Michael Barnes, counsel to Aimed Alliance, and Ashira Vantrees, director of Legal Strategy and Advocacy. And I'll turn it over to Ashira to kick off our discussion.
Great. Thanks so much, Olivia. Thanks so much, everyone, for joining today's conversation. As Olivia said, my name is Ashira Vantrees, and I'm the Director of Legal Strategy and Advocacy at Aimed Alliance. And today's conversation is really intended to be an overview of what judicial advocacy is and how it can be incorporated into your broader advocacy strategy and planning work. So just to go over a quick agenda for today's conversation, I'm going to kick off the conversation by talking about the importance of our checks and balances across our three branches of government. And then I'll provide an overview of how our federal and state court systems are set up. And then I'll turn it over to Mike, who's going to give us some more information about the logistics of lawsuits, and who's also going to provide us with a case study on how litigation can be used as part of advocacy. And then we'll finish up with sharing some resources, talking about Aimed Alliance's new judicial advocacy working group. And then, like Olivia said, we'll leave a couple minutes at the end for questions. So kicking us off, I'm going to take you all back to your high school civics class and talk about our checks and balances. Essentially, our checks and balances system is this idea that the founders didn't want any one branch of government to have too much authority, but they wanted there to be checks on each other. And so that's how we created this oversight of each branch. And so this chart is kind of like a big picture overview of how the checks and balances work. It's not exhaustive of all the roles of each of these branches, but it does give us a good idea as to the roles of each. So as we all probably are familiar with, the legislative branch is responsible for making laws. And the check on that is that the executive branch has the ability to veto those bills, and the judiciary can deem those bills unconstitutional. Similarly, the executive has primary enforcement authority. And the check on the executive is that the legislative branch can impeach the president and has to confirm heads of agencies. And again, the role of the judiciary here is to determine if the conduct of the executive or enacted laws is constitutional. And that brings us to the last branch, which is the main point of our conversation today. So the role of the judiciary is to interpret laws and to determine if they're constitutional or unconstitutional. And when we're thinking about how we have oversight of the judiciary, we can think of it kind of like in a spectrum of the lifespan of a judge. At the beginning of a judge's career, when they're appointed to the judiciary, they're appointed by the executive and confirmed by the Senate. And then if during their course of tenure as a federal judge, which is a lifetime appointment, there is some sort of misconduct, the legislative branch does have authority to impeach judges. And they have done so in a handful of cases, but as most recently in 2010. So it is an authority that has been exercised before. And really the big takeaway I want you guys to get when we're talking about checks and balances is where the judiciary is at in our legislative process, right? And really how they're the last safeguard on making sure an unconstitutional law isn't applied to people. So for example, if there's an unconstitutional law that's passed by Congress, the executive doesn't see it as unconstitutional, that last stop is going to be a district court to determine if that law can actually be applied. And so it's really important that we recognize the value of using that court system to make sure our laws are constitutional and consistent with the principles of our country. So now I'm going to talk about the federal court structure and how you get into federal court, and then I'll do the same thing for state courts. So within our federal court system, we have three courts. We have district courts, appellate courts, and our Supreme Court. So district courts, there can be a number of district courts in each state, and these are the trial courts. So they're going to be doing civil trials, criminal trials, they'll do your hearings. And then the district courts are subject to the rules of the appellate courts. So there's only 13 appellate courts, so obviously not enough to cover every single state. So each appellate court has a select number of states that they're responsible for the decisions of those district courts. And I'll go over a map in just a moment. But what's important to understand about the appellate courts and the district courts is the district courts are only bound by the decisions of their immediate appellate court. So for example, Florida district courts are subject to the jurisdiction of the 11th Circuit Court of Appeals. But a Florida district court is not bound by the decisions of the 5th Circuit Court of Appeals because that would only be persuasive. But like I said, everyone in the 11th Circuit, so Florida, Georgia, and all Alabama district courts would be subject to that 11th Circuit's decisions and bound by it. Our final court is the Supreme Court, which is the final arbitrator of all legal things. And decisions by the Supreme Court are binding on all courts, so all district courts and all appellate courts. And one of the ways we often see cases get to the Supreme Court is when we have something called a circuit split. So that is when, let's say, the 11th, the 4th, and the 3rd Circuit have interpreted a legal issue one way, and then the 5th, the 10th, and the 9th have determined it another way. So because there's that circuit split, there's a chance that the Supreme Court will look at that case and determine how the federal law should be appropriately applied. Federal court jurisdiction is not for everyone. You have to meet certain requirements in order to enter federal courts. These are the two most common ways and types of cases that we see in federal court, but there's a number of other ways that you can get into federal court related to ambassadors, maritime law, but these are the important ones for kind of what we see in civil litigation. So the first way to get into federal court is through the federal question doctrine. And essentially this says, if it's a lawsuit about the US Constitution, the federal government's conduct, or federal law, we want that case to be heard in front of a federal judge at the district court level. The second way that we often see cases come before federal district courts is through diversity jurisdiction. And diversity jurisdiction essentially says that if there's two parties from different states, so let's say Florida and Georgia, and they're suing for an amount over $75,000, that case can also be heard before a district court. And the reason for that is there's this concern that a state court may be preferential to one of the parties if that party is from their state. So for example, let's say a Florida plaintiff is suing a Georgia defendant in Georgia state court. That case may be appropriate for a federal court jurisdiction because the concern is that this Georgia state court would be deferential to the Georgia defendants. And so by removing it to federal court, there's more of a neutral territory. So that's kind of the big picture overview of how the federal court system is set up and how we often see cases enter the the district court's jurisdiction. The state courts are very different than the federal courts. So our federal court system has been created by the US Constitution, and the state court systems operate very similarly. They're creatures of their state constitutions. So many states will operate very similarly in that they're going to have their trial courts, their appellate courts, and their Supreme Court, but not all states. There's 8 states who don't have appellate courts, so any sort of decisions from the trial court that have to be appealed go directly to those states' Supreme Courts. You may also see in the state level some more specified courts, such as probate court, juvenile courts, to really spread out the workload of the states. Mike, I see you unmuted. Did you want to jump in?
No, just
No?
getting ready to do my part.
Okay, no worries. And a key difference as well at the state court level and the federal level is that all federal judges are appointed by the president and confirmed by the Senate. At the state level, how judges come into their positions varies. So they can be appointed by the governor, they can be elected in bipartisan or nonpartisan elections, they can be appointed by the governor and then subject to retention elections. So it really varies. And if you want to understand how judges are appointed in your state, I encourage you to look at the Brennan Center for Justice Judicial Selection Map, which is an interactive resource that you can just click on your state and it'll tell you how judges are appointed. The other key difference from the state courts and the federal courts is that federal judges are lifetime appointments and state court judges are typically for selected terms. Again, it's going to vary on a state-by-state basis, but there is that difference in tenure. The last thing that's important to recognize from state courts and federal courts is that federal courts are typically assessing issues of federal law. State courts are looking at issues of state law, but they can both, in certain instances, review. For example, a state court can look at federal law, but then of course they have to apply federal law to that question. And a federal court can look at state law, but then they have to apply federal law to the conduct in question. Typically, state law, it'll go through the appellate court and the Supreme Court, and it won't be appealed to a federal court unless the federal court believes there is some sort of constitutional violation. So state decisions are, the final arbitrator is usually the Supreme Court, unless the state court has made a decision about how federal law is applied. If a state court is deciding how federal law applies, then that interpretation could be subject to review by an appellate court. So there are situations when appellate courts can review state court decisions, but it's not often. So that's our big picture overview of how our state and federal court systems are set up. I'm going to turn it over to Mike, who's going to give us more of a rundown of the logistics of how litigation works.
Thank you, Ashira. We're talking today about civil litigation. Of course, you know that there's also criminal enforcement of laws, but we're going to be talking about when two parties have a dispute, and that is managed through the civil litigation process. And typically, when you look at entertainment, say television or movies, you see the trials, right? But if you look at this list of civil litigation procedures, you see that trial is toward the end, and it's just one portion of the entire process that can cost tens of thousands of dollars or more, of course, into the millions, and at minimum last months, but typically last years. Civil litigation starts with a complaint. And that complaint must include the court's jurisdiction. And so Ashira was describing the sources of federal jurisdiction, for example, with the subject matter of federal question, right, or diversity. But that's only one form of jurisdiction. There also needs to be the personal jurisdiction, which refers to the territory, right? So if I am coming to file a lawsuit in the District of Columbia, in the state court of the District of Columbia, then we need to make sure that whoever is going to be the defendant has a tie to the District of Columbia. And so that is really the territorial or the personal jurisdiction aspect that complements and is another requirement in addition to the subject matter jurisdiction. The complaint has to include your claims. What are you claiming occurred factually, and how has that violated the rights of somebody in accordance with what we call the elements of a law, which are basically the checklist of items that must be satisfied for a claim to be valid. The complaint also includes a request for relief. So what are the damages that you have experienced, and what are you asking the court for? And so that could include, for example, monetary damages, but it also could include an equitable remedy of doing something. So for example, seeking an injunction is another form of relief that could be requested. And we'll talk about some cases involving injunctions shortly. Then we move on to the service of process, which is making sure that the defendant has notice of the lawsuit, making sure that that individual is served. And we have process servers. Oftentimes, those are deputies with law enforcement. And that can be a process that is actually hard. Oftentimes, defendants want to make it difficult for service of process because that typically is a basis for dismissal. And that brings us to the first response of the defendants after they've been served process is typically a motion to dismiss for any sort of reasons, failure to appropriately serve the process, lack of jurisdiction, or failure to state an adequate claim or satisfy those elements of the claim. The response from the defendant also will include the factual denials as part of an answer. And then affirmative defenses. Affirmative defenses are effectively reasons why the defendant did what the plaintiff claims, and why the defendant should not be held liable. And so an example of that we'll discuss in greater detail in affirmative defense is contributory negligence. So if you have a negligence action saying that somebody didn't follow the duty that that person had, a defendant can say, okay, but you also were negligent, and therefore my liability is either reduced or especially in some instances altogether negated by this contributory negligence. And that certainly is something that can occur in healthcare litigation, and we'll discuss that defense in greater detail. The answer also can include counterclaims where the defendant is going to sue the plaintiff back. And so that typically is included in the answer. Then we move on to the discovery process, which is basically discovery of all the evidence that would be presented at trial. What is compiling the record of this case? Everything that's going to be presented at trial must be discovered through this process. And that includes subpoenas, where there's an order issued from a court for an individual to produce documents, or a subpoena to come and testify, to provide oral testimony as part of a deposition, for example. And this is a very long and costly process as well. Discovery can take years, as we'll discuss in greater detail. After that process, once discovery is concluded, then we move into the procedures of additional motions. And this is where a defendant might say, well, this case should be dismissed because there wasn't appropriate evidence. You didn't provide the evidence to satisfy those elements of the claim. And therefore, we're asking the court for what is called summary judgment, which is just basically that there are not enough facts to support the claim, and therefore the case has to be dismissed. And so these procedural aspects of litigation are a part of the defense strategy, of course. They make it very difficult for a person or plaintiff to bring a claim, very time consuming and extremely expensive. And we'll discuss a case in which every single method of these sorts of procedural defenses through the motions opportunities has been utilized. Oftentimes, courts have, through their local rules, which are the rules that courts would issue distinct to those particular courts, they can require mandatory mediation. And so, for example, we know that mandatory mediation is a part of medical malpractice claims under DC law, but we also know that under certain local rules, for example, federal courts, they can say that mediation must be included as part of the process as well. And so that would be either the subject matter, the substantive requirement under law, or the procedural requirement under the rules of the court. And that's typically the opportunity for the parties to go back and forth, oftentimes with a judge or an experienced attorney as a mediator, to try to solve their issues between them before they go to the more costly formal trial. The trial is what everybody is familiar with, where you bring the witnesses into the court, they discuss the facts, and then the jury is given instructions to apply those facts to the elements of the law, the elements of those claims that we've discussed. And they'll come back with their findings and the verdict. And sometimes it's a jury, sometimes the fact finder is the judge itself. But both the jury and the judge would be deemed a fact finder as part of the trial process. And then, of course, there can be an appeal. So, for example, if a federal court issues an injunction and say that the defendant opposes that and would like to be able to continue the activity that has been enjoined by that court order, they could appeal, and then that continues all the way up potentially through the Supreme Court, as Ashira was describing, and as we may be seeing soon as part of our current events related to injunctions, related to executive actions. So moving on to health policy specifically, and the plaintiffs that we can have as part of health policy litigation. We have the individual, and an example of an individual plaintiff would be medical malpractice. Say, by example, we have the estate of a person who died. The survivors of the person who died believe that the medical healthcare provider was negligent, and therefore they bring a medical malpractice claim. That's a way that actually can be used to influence policy, as we'll discuss in greater detail during our case study. All of these types of plaintiffs can actually use litigation, the civil process, to influence policy more broadly than just their own set of facts. Healthcare providers can bring actions. We've got an example of that is covered in our litigation tractor, AIMD Alliance's litigation tractor, which we'll discuss in greater detail. This is a case, by example, where a bunch of healthcare providers from across the nation have come together and brought an antitrust action against health insurance companies and one of their subcontractors that basically compiles data and determines what amount the insurance companies will pay out-of-network providers for the services that they provide. So out-of-network providers typically would verify that there's insurance, but they don't have a contracted rate for the services they provide. The health insurance company typically will receive claims and then determine how much to pay based on data that a company like the defendant in this litigation multi-plan case. And so the allegations by the healthcare providers in this civil litigation are that this is information, this is a practice that basically violates consumer protection laws and violates antitrust rules. And that is a case that has brought together plaintiffs from across the country for multi-district litigation, where the same issues are being brought by plaintiffs from multiple federal districts, and they're consolidated. In this case, the case is consolidated in the Northern District of Illinois. Industry can bring a case through the civil litigation process as well. So we see that an industry association, pharma, has brought a case along with some members of the pharmaceutical industry in West Virginia. And they've recently obtained an injunction, again, that equitable relief where the court is saying you have to stop this particular act. And that was against a West Virginia state law that limits the ability of drug companies to obtain data through their audit rights at the federal level under the West Virginia law. And so that's a case that we also are covering in the Aimed Alliance litigation tracker. And then finally, not-for-profit organizations have an important role in health policy litigation. We've seen that just recently through the case brought by the National Council of Nonprofits and the American Public Health Association. They recently attained a federal preliminary injunction blocking a federal spending freeze from the new administration in Washington, D.C., and the Office of Management and Budget, a federal agency, has appealed that on behalf of the federal government. And so, again, these are important cases that are all very timely and a part of current events in health policy. So moving on to the next slide around other lawsuit participants, there are also interveners. And these are organizations or individuals who want to participate in a civil case because they believe the case or its outcome may affect their rights or duties. And so there are two types of interveners: those that come as a matter of right, get their rights through a statute to make sure that their rights are adequately represented in the case. They, by law, have a right to intervene. And then permissive intervention is when a party or an entity that chooses to become a party to the litigation is in a situation with a common question of law or a common factual scenario. And the permissive nature of that is that the judge can decide to accept or not accept the intervener as a party to the matter. And the important part of that is to that the intervener and that intervener's participation do not infringe upon the rights of the original party. And so that is another way for entities to become involved in litigation. And then I think many of you are likely familiar with the amicus process. Amicus curiae are friends of the court who bring to the attention of the court relevant information that is not already provided by the parties. And the plural form of amicus is amici. And so they commonly file briefs at the appeals stage, but it is possible to file amicus briefs in federal district court as well. And so the next slide shows just a couple of the cover pages of amicus briefs that I've worked on with colleagues and for other not-for-profit organizations. And they are intended to illustrate that judicial advocacy really requires significant resources. I've already mentioned the amount of time it takes, the amount of budget it might take in terms of litigation expenses and fees. But you also have to have, even as an amicus filing a brief, you have to have the subject matter knowledge so that people like our audience members who know their area of health policy and know, for example, the aspects of medical treatment for people who have a certain health condition. And then additionally, you have to have someone who knows litigation, right? Someone who is admitted to practice in a specific court. So that person has to have the license to practice and then be admitted into those courts to be able to practice law. And finding that type of person is often difficult, especially if you're hoping to find a pro bono counsel. And pro bono counsel is typically a volunteer that will give its services for no cost to not-for-profit or other organizations, and they do so in the public interest. Typically, it's difficult to find pro bono counsel to bring public interest amicus briefs or other litigation because, of course, the nature of the work is very time consuming and very complex. And so the amicus process also requires that new perspective that is not otherwise represented by the parties. And just like with your advocacy at the executive level and in the legislative branch, you want strength in numbers. And so you want to find other people who are going to sign on as additional amici to be able to strengthen the case that you're making as a not-for-profit organization, for example, in the public interest. Distinct from the parties that might be, for example, like in the West Virginia case, industry members or the state government, right? Not-for-profit organizations can come in, hopefully together with strength in numbers to be able to share the public interest as friends of the court. And then preparing these briefs, no matter who you are or what you're doing, requires multiple reviews, a lot of formatting. You can see here the ornate nature of formatting of an amicus brief to the U.S. Supreme Court, and then filing. And the funny thing about as ornate as this cover page is on the left-hand Supreme Court amicus brief, they still got my name wrong. And so no matter the resources, it's very difficult to do this job right. So this brings us to a case study that is going to highlight how we're able to use judicial advocacy to supplement executive and legislative branch advocacy when we feel like those efforts are not yielding the progress fast enough that we would like to see from a health policy perspective. And so we're going to be talking about warm handoffs. Warm handoffs, really the notion is specific to substance use disorders. And we're going to start with the case of Richard Perry on the next slide. His mother, Karen Perry, is the founder and executive director of the not-for-profit NOPE Task Force. And she founded that organization around 2004 after her son died of a second overdose. And so Richard Perry initially experienced an overdose. And as we'll see on the next slide, the hospital that treated him basically did what is called treat and street. So basically made sure that he had continued to live, right? So still breathing, still got a heartbeat, and then sent him back out in the street. And in this case, he had presented to the hospital with an opioid overdose and left the hospital in withdrawal because he had opioid use disorder, was able to survive the overdose, but then was released without medication to control the withdrawal cravings. And so within weeks, he had yet another overdose. And in that instance, unfortunately, he did not survive. And so Karen Perry made it the remainder of her life's mission to advance what we call warm handoffs. And warm handoffs are basically recognizing that substance use disorders are medical conditions and that they needed to be treated as such. And so that means either giving treatment, in the case of opioid use disorder, that's evidence-based treatment with medication, or referring, right? So if you're a provider and you're not comfortable with that area of practice, you give a warm handoff to another provider to make certain that the person who needs medical treatment has gotten the medical treatment. And so it's part of the advocacy that I've done and other organizations with which I work, including NOPE Task Force and Karen Perry have done. We've certainly monitored the medical literature and made certain that the medical literature accurately reflects that medical practice requires that there be appropriate treatment or a warm handoff referral for people who have substance use disorders, and specifically people who present with opioid overdoses. And as part of our advocacy, and I want to highlight that this is something that AIMED Alliance is very good at, and it's seeding the literature as part of the advocacy, we seeded the literature from a legal perspective with information on warm handoffs and the legal duty, conducting the legal analysis, and then even providing a draft policy for hospitals to use as a starting point for their own warm handoff policies. And this is something that is a crucial part of judicial advocacy because it really sets the record that can be used by experts in civil litigation who will ultimately be informing the fact finder, either the jury or the judge, about what the standard was that had to be met at a certain period of time. In the case that we're discussing today, we have a 2018 death from overdose. And so we look back in that case to what was the legal literature, what was shown in the medical literature in 2018 to support the opinions of the medical experts. And so that certainly reinforces the need as part of advocacy to see the literature from a medical and a legal perspective. And we had done so with the medical literature coming out in 2015 and 2017, the legal literature. But still, we were not seeing adequate progress. We had efforts in Florida to have a law passed. We worked with then Attorney General Pam Bondi when she was AG of Florida. And she and her office were instrumental in getting a law passed in Florida that required hospitals to have warm handoff policies in place. Unfortunately, that law at the state level didn't have adequate enforcement provisions. And so the hospitals that don't comply with the requirement to have these policies in place to prevent additional future overdoses, they're not subject to any sort of penalty. So the law is largely toothless and ineffective. So it's frustrating, but certainly the result of good legislative advocacy on the part of hospitals and their associations as an industry. And then at the executive level, we saw one state, Pennsylvania, that as part of an emergency healthcare order, ultimately achieved 95% coverage of hospital warm handoff programs. So 95% of the hospitals in Pennsylvania as of 2021 had warm handoff policies and practices. And that was terrific, but it was one out of 50 states plus DC that actually had this level of coverage. And so that also exemplifies our frustration of the inadequate progress that we were making with our legislative branch and our executive branch advocacy. And so on the next slide, it brings us to our desire to find a way to get the judicial branch involved. And the idea was that we want to get healthcare providers to recognize that they have a legal duty to provide these warm handoffs to medical treatment for people who have substance use disorders. But we also want the insurers, so the insurers of hospitals, the insurers of healthcare providers who provide malpractice insurance, they also need to be involved to encourage and require that there be these policies to provide treatment for people who have the medical condition of substance use disorder or opioid overdose, for example. And so it literally took me 3 hours to find an appropriate plaintiff to bring a lawsuit to try to get this case law up to date so that we verify the legal duty and activate the insurers. I had lunch with a colleague and friend who runs a treatment program in the District of Columbia, told him our desire as part of this advocacy. He had been involved as part of the legislative and executive advocacy for years, understood the issue, and had a friend and colleague who's an addiction treatment provider here in DC. Within 3 hours, I was on the phone with that physician, Dr. Edwin Chapman, who had a patient whose brother had been profiled in the Washington Post in what the Washington Post deemed pure incompetence, where in his case, Victor Williams was a person with a long-time opioid use disorder. He experienced an opioid overdose. He went to a hospital in Washington, D.C., where they admitted him for pneumonia. They treated his pneumonia. They treated his pain. They did not treat his opioid use disorder. And instead, they actually gave him additional opioids as part of his pain treatment. And so rather than actually treating the reason why he came into the hospital, his opioid overdose, they actually exacerbated it by giving the message that it's okay to continue using opioids. And ultimately, when he was discharged from the hospital, he was left in a state of active withdrawal, just like we discussed with Richard Perry. And that means by the medical scientific findings in literature that he had a disease that was characterized by a compulsive need to use the substance. In this case, it was opioids. And so that compulsive, uncontrollable need led him to go out and find substances through the illicit market in Washington, D.C. And this was at a time when these substances were largely um, contaminated with fentanyl. And oftentimes people who use them were not aware that fentanyl was in the product or the amount of fentanyl. And so within 14 hours of Mr. Williams's discharge, he was dead. Right. And we had a hospital and physicians who had had the opportunity to provide a medical treatment, and they didn't. And so we brought a lawsuit on the part of the family, the son, Victor Gordon, and then Victoria Williams. The son represents the estate as well as himself, and then the daughter is party to the litigation as a plaintiff as well. And they sued, among other parties in this neglect of Mr. William, they sued the hospital and the physicians. And so we can see on the next slide that this case we brought in September of 2020. And then we went through every single type of procedural defense, and we still will likely have more throughout the duration of this case. 5 years later, we've just now survived a motion for summary judgment. But you can see through this timeline, as well as we have the aggregate fees of just one set of attorneys on the plaintiff's side, right? And so we've got with two attorneys on the plaintiff sides, and then attorneys on each of the defendants. There are four different defendants. All of those have legal counsel, and you can get an idea as to how expensive this case has been just by looking at the plaintiff's side fees. One of the law firms working on the plaintiff's side, and that's the one with the subject matter knowledge, but not necessarily the procedural courtroom knowledge, the litigation knowledge. And so we're talking about at this point just that one firm having put in $250,000 worth of legal services over the course of 5 years, trying to get there to be accountability to provide medical treatment with substance use disorders. But the insurance companies have been willing to pay their defense attorneys to continue to litigate and to continue to delay through every single procedural motion possible, because they realize that this will open the floodgates, right? If they allow there to be either a settlement or a judgment in favor of the plaintiffs. And so they're continuing to press forward after 5 years, paying these legal fees rather than paying the plaintiffs for the losses that they experienced. And so fortunately, as part of summary judgment, we were able to get a written opinion from the judge. And this slide shows a portion of the written opinion that is very important to us because it addresses that affirmative defense of the defendants. And this is so frustrating and typical, but when you're dealing with someone who has the health condition of substance use disorder, it's the blame the victim concept, right? It's the easiest defense possible, I suppose, especially as you're relating to a highly stigmatized condition. But fortunately, through this process, we were able to get medical experts to provide factual input into the record that Mr. Williams was dealing with a compulsive medical condition that required him to use substances and that he had no control over. And so that affirmative defense that he was contributorily negligent for his own death required that he actually choose to have used substances, that he have chosen to use substances, right? And so what we were able to develop and show through the expert testimony, including one of the defense experts actually supported this notion that the addiction is a compulsive disease where the inability to control the use, right, contributes to one's going out, obtaining a substance, taking the substance, and in Mr. Williams's case, dying of an overdose. And so the judge determined that you cannot say that the decedent, in this case, Mr. Williams, was necessarily contributorily negligent And the judge recognized that that is because we have evidence that he had a compulsive brain disease. And so that's huge. Just this makes it, from a health policy perspective, worthwhile to have brought this case. But we still, as you see on the prior slide, we still have to go through mandatory mediation. We'll still go to trial. I'm certain that we will go to trial because the defense counsel, the insurance companies do not want to pay out and open those floodgates. And trial will likely be at the end of this year. But regardless, we have important case law now that provides a basis for additional plaintiffs to come forward and, as we're doing with the case in Washington, D.C., encourage for there to be accountability among the physicians as well as the insurance companies, pressuring those physicians in the hospitals to provide appropriate medical treatment to individuals who have opioid use disorders. So on the next slide, going over to the warm handoff policies, you will see that we have made progress. Just looking at 2023 to 2025, we see that more states now have warm handoff policies. So we were right to be impatient, but certainly we are seeing progress. And I think this is largely due to the advocacy work that we did surrounding the opioid litigation in the United States, where there were a lot of lawsuits against opioid medication manufacturers. And as part of our advocacy, we did a model opioid litigation proceeds act. And that model act made it clear that the funds could and should be used for policies like warm handoff policies and practices in hospitals. And so thanks to that opioid litigation and the proceeds that are coming out to the states, I would say that's largely responsible for the improvements that we see with these red states between 23 and 25, 2023 and 2025 that are actually implementing warm handoff policies for hospitals. And so we do see that also as an important aspect of the advocacy that we've done that is yielding results. So more than 20 years after Richie Pere's death and more than 7 years after Victor Williams's death, we are seeing signs of progress, and it makes it worthwhile to continue our advocacy at all three branches of government. So this brings us to our resources and work plan for AIMED Alliance and the work that we hope to do with organizations like yours. We have a litigation and case law tracker that basically every quarter we'll discuss some of the important cases in health policy. And you see the one highlighted here is the case surrounding those provider payments, the multi-plan litigation, that multi-district litigation, where we try to do a very concise summary of what is happening in this case, and then provide a link to additional information or a source where you can provide additional information if you are interested in following this case yourself. So this summary came out in our edition that was released in early May. Our next edition will likely come out in July. And we will provide any sort of update on this case and the other cases that we summarized in our prior litigation tracker to keep you up to date on the progress that we're making. We'll likely not provide you updates on all the procedural motions, but rather look to the substance and where we're seeing that there could potentially be changes in health policy. Another aspect of the litigation and case law tracker is that we are looking at cases where not-for-profit advocates are taking a role. So either as plaintiffs, as we discussed, not-for-profit organizations can be plaintiffs like the public health plaintiffs in the injunction for federal spending freezes. And then they also can be amici, as we see in the case that I previously discussed in the West Virginia law surrounding 340B drug pricing requirements and the state laws impacts on the rights of pharmaceutical companies to audit their drug pricing programs. Amicus briefs were accepted by the appellate court, the U.S. Fourth Circuit at the federal level. And these amicus briefs provided perspectives that were not otherwise provided by the parties, which are members of industry or a state government. And they provided the public interest perspective. As not-for-profit organizations working in the public interest, they shared their perspective that would otherwise not have been represented in this litigation. And so through our case law tracker, we will also be reporting on organizations that are doing that sort of judicial branch advocacy. We also today are releasing a glossary of civil legal terms. This is intended to help readers of our litigation tracker understand much of what we're talking about and many of the terms that are specific to judicial cases. Working on this with my colleagues, certainly learned something, if not something new, learned something again after law school, and as Ashira mentioned, after civics class. So I would encourage you to skim through. You'll certainly find something refreshing, if not new, in our glossary of civil legal terms, and that's available on the AIMED Alliance website, as well as the litigation tracker that Ashira is going to give us more details about these sorts of resources. But I do want to make sure that you also remember the AIMED Alliance newsletter, which comes out every single month. It provides updates not just on the judicial advocacy activities and the collaboration that AIMED Alliance does, but also on the work that it's doing at the executive and legislative branches, including even in trying to influence policy at the corporate levels. So you get substantive updates on that monthly. I encourage you to sign up for the AIMED Alliance newsletter if you have not already done so. And then finally, we just want to share additional legal news resources if you and your organization and your judicial advocacy efforts would like to have daily updates on what's going on. The three major providers of legal research services, LexisNexis, Westlaw, and Bloomberg, they all have their own news services. These are subscription services. They're pretty expensive, but they are pretty thorough if you're interested in knowing what's happening in health law on a daily basis across the country at federal and state levels. So thank you for your interest. Thank you for your attention. Thank you for your time. I'm going to send it back to you, Ashira.
Great, thanks, Mike. And Olivia, we'll go over where it is on the website right after we talk about the working group, if that works. That overview is really helpful, Mike. I think it's a great example as to how litigation can be used in support of advocacy when you've already made certain strides with the executive branch and with legislative branches, but you still need something more. And that kind of brings us to why we've decided to launch a judicial advocacy working group, and why now is really an opportune time for patients and providers and caregivers to have a more active voice in this space. And there's really two big things that I think were the precursors to this decision to create this working group. So the first one was the Loper-Bright decision, which many of you may have heard of. And essentially what the Loper-Bright decision says, which came out by the Supreme Court in June of 2024, is that the Chevron deference principle has been overturned. And so what is Chevron deference? Chevron deference is a principle that was created by the Supreme Court in 1984, which said that when district courts are reviewing agencies' interpretation of ambiguous statutes, the district court should be giving some deference to the agency as to their interpretation. And the reason in Chevron that they decided to get that deference is because the agency is the expert on that matter of work. And so the agency is likely in the best position to understand what Congress likely meant when it was making this statute and codifying this law. And this was a really important piece of precedent in administrative law and the longstanding position for nearly 30 years until June of last year when the Loper-Bright decision came out. And the court said clearly that the Chevron principle is overturned. So what this means is now district courts, when they are reviewing agency conduct, they are not required to give any deference to the agency's interpretation of the statute. This means that essentially courts are going to be looking at things for the first time with fresh eyes and can create their own interpretation. So I think for advocates who've done a lot of work engaging in administrative advocacy with the agencies, we now have a really unique opportunity to kind of get a second chance at things. So for example, if an agency comes out with an interpretation of a statute that's unfavorable to patients or providers, there's now an opportunity to take that interpretation to a district court and have a second set of eyes reconsider it in the first instance. So that could be a really exciting opportunity. But in the same breath, on the other side of that coin, is that if we do get a favorable interpretation from an agency, we may also see that interpretation subject to litigation from opposition. In both those instances, it means that we need to be vocal with the judiciary and the district court to make our perspectives heard through things like amicus briefs or supplemental information, or figuring out ways to get before these judges and make sure patient impact is top of mind for them when they're making these decisions. The other big reason that we're seeing a really urgent need to engage in judicial advocacy is some of the conduct that we've seen from the executive branch and the judicial branch. So you may be familiar with this case. It's an immigration case where a man was deported to El Salvador, and the district court held that the federal government improperly deported him to El Salvador because they failed to provide him due process, which essentially means notice and an opportunity to be heard. And so the district court said that the government needed to facilitate his return so he could get that due process. The court didn't make a substantive decision as to whether the federal government met the requirements to deport him. They just said they have to go back one more step and make sure he's getting that initial notice and opportunity to be heard. This case was escalated to the Supreme Court of the United States, which affirmed the district court's decision, saying that yes, because the federal government failed to provide due process, it does have an obligation to facilitate the return of this individual from El Salvador so they can get that initial due process. In response to the Supreme Court's opinion, the executive branch has been clear that it does not plan to make an effort to facilitate this return of this individual so they can get that initial due process as required under the Constitution. And so, although this is an immigration case, I think it's really important to highlight because it really jeopardizes that whole checks and balances that I was talking about, right? So if one branch doesn't respect the oversight that the other branch has on it, then that gives that branch, more authority to become that ultimate decision maker without oversight and more unchecked authority. So it's really important for, I think, us as advocacy organizations who have typically, engaged with the other two branches to start engaging in judicial advocacy and showing that we value this mechanism of accountability and we believe it's a viable path for reform as well. So kind of with all of that in mind and with the benefit that Mike has discussed about bringing litigation and lawsuits as part of the advocacy strategy, we are excited to announce that we are launching our Judicial Advocacy Working Group. And this group is really intended to provide a convening space for advocacy organizations who want to better understand and engage in judicial advocacy and can ensure that the consumer perspective is represented within all areas of law, including the judiciary. And one of the reasons we've separated it into these two groups is because we wanted to make sure that we were providing some really robust legal analysis from those who have training in the law through attending law schools or being licensed litigators. And we also wanted to make sure that we were, not getting too pigeonholed in our legal analysis and discussions and making sure we were continuing to stay abreast on the emerging issues that patients are experiencing. So that's how we created our two working groups with our different thought leaders. And I think one of the really big values of this working group is that, just like Mike said, litigation is costly. Writing an amicus brief can be challenging and time consuming. Finding pro bono counsel can be hard. If you're not a lawyer, understanding how the legal system works and where it makes sense to plug in is really challenging. And so the goal of this working group is really to make those opportunities easier so we can get our patient perspective and we can get our provider perspective heard by more folks who are going to be decision makers in the first instance. So with that, I'll turn it back over to Olivia, who can maybe just give us a brief show of where those resources are at on the website and then open it up for any questions.
I'll jump in to show those resources that we had mentioned earlier. First, you'll want to navigate to the AIMED Alliance website, which is aimedalliance.org. And from the home page, you'll find the Initiatives tab at the top of the page. And in the drop-down menu, you'll see the number of these options, and you'll want to click Judicial Advocacy. And this will take you to our Judicial Advocacy Hub, which serves as a centralized space for legal resources, updates, and tools aimed at helping advocates better engage with the judicial system that Mike had mentioned earlier. So once you're on this page and you scroll down a bit to the bottom, you'll find the litigation and case tracker and the legal glossary. And so you'll see other resources on this page as well, like amicus briefs and recent court decisions. And so that just provides a quick look on how to access these resources, and we hope they'll be useful to you as you think about opportunities to engage in judicial advocacy moving forward. And so with that, we can shift to our question and answer portion of the webinar, and we invite attendees to submit any questions using the Q&A feature or to raise their hand if there are any questions at this time.
Just the other thing I wanted to flag, Olivia, is that, as we're building out this working group, we want to be responsive to the issues that folks are seeing in the patient, the provider, or in the caregiver space. So if there is an issue that you're seeing in your community where you think there may be an opportunity to engage in some sort of judicial advocacy or better leverage the law and the understanding of the requirements of the law, feel free to reach out to us at the email that's on the screen, policy@aimedalliance.org, and we're always happy to have a conversation and bring it to the working group to see if it's something that we can address.
That's a great mention, Ashira. It doesn't look like we have any questions at this time, so we can go ahead and wrap up. So just again, want to thank you all for joining us today and being a part of this conversation on judicial advocacy. We hope you found the discussion helpful and informative as you think to incorporate legal strategies into your broader advocacy efforts. If you have any follow-up questions or would like to connect with us further, please don't hesitate to reach out. So thank you again for your time and engagement, and have a great rest of your day.
Thanks so much, everyone.